It was for her safety, Your Honor.
No, that's not for her safety. Let me ask you, do you all have reverse locks on your doors?
No,
But it would be for your safety.
Juice Brown is facing a state jail felony after leaving her 3-year-old child alone at home while she went out to buy diapers.
Court is calling 2024 CR 3364, State of Texas versus Julexis Brown. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Valerie Hetland for Alexis Brown.
And are you Ms. Brown?
Yes, ma'am.
Counsel, have you received all of the discovery?
Yes,
And did you review it with your client?
we did.
Court will find that the state is in compliance with discovery. Ms. Brown, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes,
Did you
ma'am.
understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment?
Yes,
Did you understand it?
yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Ms. Brown, did you review the document entitled Court Admonishments
Yes,
with your
ma'am.
attorney?
Yes, ma'am.
Did you understand it?
Yes,
Did you sign it in all the appropriate places?
yes, ma'am.
Did you understand you're charged with the offense of abandoning a child with intent to return as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yeah.
Ms. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Ms. Brown, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state recommends deferred adjudication and you're to follow any and all CPS directives. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
All right, so with regards to following any and all CPS directives, as someone who's practiced on the CPS side, I think that may be overly broad and it may potentially interfere with the representation that her attorney has. So maybe if y'all just said CPS compliance.
Absolutely, Your Honor. We're happy to make that notation.
And just for the record too, the CPS case was only investigation. It didn't go to the 252, it didn't go to family base, and it was closed.
Okay.
So it shouldn't be a problem.
And I'm just asking that they put CPS compliance, because if you have a CPS attorney or they become involved in this case on that side, they may want you to do specific things or have objections to specific things. You're welcome.
Judge, I had to move the stanchion up, so I'm not as thin as I used to be.
All right, and then so there's to be CPS compliance if applicable. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer states one and attachments.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the document entitled Waiver and Consent to Stipulation
Yes, ma'am.
of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Bring it up. You want to say that I attached before? Can you do it again? All right, let's see what the mental health evaluation says, okay?
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just, Judge, she regrets, she understands what she did was wrong. There's no minimizing what happened. She was going to the store to get diapers. It was late at night, right before they were going to close. There's some disputes among the times in the report on how long she was gone. She did have a nanny cam there, not to excuse the risk that she put her baby in, but her daughter was asleep. She was watching her on the nanny cam, came back. And there's also some custody child support issues. So the husband or the ex, her daughter's father had been there at the house waiting for her to leave, and then he had called the police, Judge. So she's not here to make any excuse for what happened, and definitely knows better.
How old was your child when you left?
She was 3.
Okay, so you left a 3-year-old by themselves at night. And the guy that you're living with, what is his relationship to you?
He's basically just my boyfriend right now.
He's your boyfriend.
Fiance, but
So your fiance boyfriend, according to the stipulations, you left to go get diapers?
she was on her last diaper.
No, I need to say yes or no.
Yes.
All right, so you go to get diapers and your boyfriend, Adam Hernandez, does he love you?
Yes, ma'am.
Does he love your child?
Yes.
Then why does it take 2 people to go get diapers and leave a 3-year-old unattended?
There's no.
There is, I mean,
Yeah.
she does have.
No, tell me why. I want her to tell me.
Explain the.
Like, why? Why would 2 adults who claim to love a 3-year-old leave a 3-year-old by themselves while they went to the grocery store or wherever store they went to get diapers? Why does it take 2 adults to go do that?
If I go by myself, I get harassed wherever I go. I know it's no excuse, but the HB that I was living at nearby, there was a guy that.
So why
works
couldn't he
there.
go?
Because we just didn't have enough money. The coupon expired after that night.
So I
and-
don't understand. You don't have enough money
Yes, ma'am.
and the coupon was going to expire.
Yes.
So there are
that's it.
two adults. Why does it take two adults to go pick up an item from a store? I don't understand.
So, if he would have gone, he would have not used the coupon, we wouldn't have had enough money. I mean,
Well, so let me just tell you the choices that you're making. You had a choice. Leave my 3-year-old by herself. Maybe the apartment's complex is going to catch a fire. Maybe somebody's just walking down the street and they notice a 3-year-old and they're like, oh, this would be a great 3-year-old to come take. So that's what you were looking at. And then on the other hand, I can save money by using a coupon. And you chose a coupon. And how much money did you get off for that coupon?
it was like $10 off.
All right, so you had a choice and you chose to save $10 over potentially something horrible happening to your child. That's basically what you did.
Yes, ma'am.
And so I still don't understand. And CPS, they do their own things sometime. I still don't I don't understand why this wasn't a legal case. And two, still don't understand why you have two adults in a household and they decide it takes two people to go pick up diapers and you all are leaving a 3-year-old by themselves. And not only are y'all leaving them by themselves, in the police report, it says the door was locked and it's a reverse lock. So 3-year-old is locked in a room and the only persons who can open that door are the two adults.
Yes, ma'am.
And we're going to unpack that suitcase in a little bit, but I'm still back to the point. I don't know if she understands the danger. And I don't know if the CPS worker stressed the danger that her 3-year-old was in by two grown adults acting as though one person can't go to the grocery store by themselves. Are you even internalizing how that sounds?
Yes, ma'am, I know it. It's.
You all can leave a 3-year-old by themselves, but you all adults can't go to a grocery store by yourself. Do you understand?
Yes, ma'am.
Now, why is it that there are reverse locks in that place?
When we moved in, the locks were on the other side. And when she was younger, she was able to touch it when she was growing up. And one time she locked herself in there, so we were scared. My fiance was able to open it. And from there on out, we decided to switch it around because we didn't want her locking herself in her room. She was getting curious. She was walking and talking and,
That's what 3-year-olds do. They walk and they talk.
yes, ma'am.
So when that officer came to that location, front door is locked and that bedroom door is locked. Yeah, and it was locked. So the 3-year-old can't get out. So let's say there's a fire that happened. Guess what? Number one, nobody's going to know the 3-year-old is there. Maybe the 3-year-old stays asleep. And the 3-year-old, if they have the wherewithal to try to get out of their room because there's a fire, they can't get out because you and your fiance have reversed the locks.
It was for her safety, Your Honor.
No, that's not for her safety. Let me ask you, do you all have reverse locks on your doors?
No, ma'am.
But it would be for your safety.
I just didn't want her locking in herself in her room anymore. That's what scared me.
All right, and let's move on to your boyfriend, Adam Hernandez. How well do you know him?
Very well, ma'am.
What does that mean? How long have you known him?
We've been together for 3 years.
For 3 years?
Yes,
And
ma'am.
how old is your daughter? 3.
She's 4 now.
All right, but she was 3 then?
Yes, ma'am.
So that means that you went from one relationship to the other. If your daughter is 3 years old and he's not is he the biological father of the 3-year-old?
He's the one that stepped up.
All right, so you went from one relationship, you have a 3-year-old, and then you're in a relationship lickety split with some other guy. And this is a 3-year-old daughter?
Yes, ma'am.
Right. And Adam Hernandez, did you do a background check?
No,
All right. Do you know if he has any criminal history?
he doesn't.
How do you know?
I mean, just because he's told me everything he's done in his past, everything that he's gone to court for, so nothing on his record.
Oh, gone to court for what?
Well, he's
For
been
stuff in
charged
the
with
past.
this, Judge.
All right. And what else? So you're just taking him at his word.
He's from,
And have you talked to any of the previous girlfriends, or if he's been married before, have you talked to them to find out why the relationship broke down?
yes, ma'am.
Oh, you talked to his previous girlfriends.
His crazy ex-girlfriend, yes, ma'am. She was
Ah,
harassing
crazy
me.
ex-girlfriend. Ah, see, you know what? I will tell you from what I've noticed in this world, there's always the crazy ex-girlfriend, the crazy ex-boyfriend. And you don't become the crazy ex-girlfriend or the crazy ex-boyfriend until the relationship ends. Then they go to the next person, and guess what? That person says, oh, she's the crazy ex-girlfriend. Let me just tell you, I don't think you've done your research to have this person in your life and trusting him with your daughter. I can't do anything about that. That's all on you. Probation, this is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. How far did you go in school?
I'm sorry.
How far did you go in school?
I graduated high school now.
All right. What are you planning on doing with the rest of your life?
Hopefully owning a business one day.
All right. So what are you doing to make that happen?
Right now, I'm just waiting for my daughter to start pre-K, just so I don't have to stay at home and watch her anymore.
All right. CPS compliance. I'm going to want field visits 1 time per month until further notice. And probation, please check on the 3-year-old and check the locks on the interior doors. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, 100 hours will be waived. The remaining 100 hours will be waived if you obtain some higher level of education or if you're in trade school. Probation, is there anything else? Yes, regular random UAs. All right, is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're gonna go off the record. You need to start putting your child first. Do you understand?
Yes, ma'am. I've been doing that ever since the day. I
All right,
got
because
arrested.
3-year-old can't take care of themselves. 3-year-old is 100% dependent upon you. And do not bring random people in your child's life unless you've done a background check. This is what sometimes parents don't understand. You know this guy. She doesn't know him. You're bringing a complete stranger in your child's life. That needs to stop. You understand?
Yes, ma'am.
All right. If you have any questions about anything, let probation know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am. Thank you, Judge.
Thank you. All right. We're going to go on the record in 2024 CR 0170. The court is in receipt of the defense's notice of appeal with regards to defendant's motion for a new trial. That will be denied.
Your Honor, can I take it that you accept this as presentment of the motion for new trial.
Yes.
Thanks.
All right, then with regards to the defendant's motion for bail pending determination of a motion for new trial and pending appeal, we'll just do it with regards to pending appeal. Defense?
Your Honor, I'd like to make a proffer if I could.
Yes.
The court knows a good deal about Mr. Meyer, of course. So the standard under 44.04C is he is eligible for bond pending appeal in light of the court's judgment, of course, yesterday.
Yes.
And the two questions are, is there good cause to believe he would not appear? And, or that he is likely to commit another crime.
All right, let me just stop you right now. State, do you think that if the court were to give bond to Mr. Meyer, he would fail to appear? And I can tell both parties, the court is inclined to place him on GPS.
I think with full house arrest GPS, I think that would take care of it, Judge.
Okay, so let's start with this. So where we are now is if he has employment,
He's
court-
retired, Your Honor. I don't mean to interrupt the court.
All
He's
right.
retired.
so it will be full GPS and counsel if you wish for him to have a window off of GPS where he can take care of personal affairs or whatever he needs to do. You need to give the court a detailed list of what time he wants and what windows of time. So for now, we know he's going to be on full GPS. All right, so next question has to do with the amount of bond. And counsel, what are you requesting for the amount of bond?
It's my understanding, Judge, and I tried to check earlier and I couldn't today, that he was on a personal bond for this case.
Mhm.
He appeared multiple times. I mean, well, just between the time he was convicted, of course, and the time of sentencing, he knew he was facing up to 20 years in prison. So I think he's a great candidate for personal bond.
All right, so here's my question. Was he previously on a personal bond?
No, Your Honor, on this cause, it was $40,000, and on the pending cause, it was $50,000. So we'd asked for $200,000, Your Honor.
That's too
Okay.
high, Your Honor.
No, here's the thing. Everyone, just address me. So, Mr. Meyer, I have some questions to ask you about this bond issue. Could you raise your right hand for me?
Yes, Your Honor.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
John Meyer.
All right, so how much do you receive in your retirement?
I don't really have a retirement. I have a house that I own and rent out in Hawaii, and
Okay.
my wife and I use that to pay our bills.
All right, so what are your bills? How much?
My mortgage on the house I live in is about $3,200. And I've been paying money out of my retirement. I've been using some of my retirement to
Okay,
pay
so
my
Mr.
bills.
Meyer, I'm sure your attorney will tell you this. Just listen to my questions because I don't want to go into other things
Yes, Your Honor.
and just answer my question. So you say your mortgage is $3,200 a month. What other bills do you have?
Electric, water.
What's the average cost of that for the utilities?
Probably about 800.
Okay. Other than the mortgage and the utilities, anything else?
No, Your Honor.
Groceries, what's the average? Per month.
500 maybe.
All right. So. And how much do you receive in income?
About 3,500.
Okay. And that's the only income you receive?
I do renovations on houses. I haven't been doing many recently.
Okay. All right, any other questions?
No questions, Your Honor.
All right, so state, are you still asking for $200,000?
Yes, Your Honor.
All right, defense, what are you requesting for bond? The court is not going to grant him a PR bond.
$50,000.
All right, so this is what the court will do. The court will set your bond at 65,000. There's to be full GPS. I'll ask that the fees be waived. But it's a third-party contract with the county. They're probably gonna send me an notation back that that fees can't be waived. There is to be regular random UAs. And probation, since probation is sort of held in abeyance till this appeal is pending, are you all able to still do UAs or no? All right. So there's going to be regular random UAs, and that's going to be through pretrial services. And there is to be sober support meetings. And those are to be 2 times per week. And my understanding is they have those sober support meetings by Zoom. All right, and Ms. Ferguson. State, I know that you may feel as though Mr. Meyer may or may not appear, but you seem to, those concerns seems to be addressed with the GPS, but this is what we will do. Norma, reset this case for 30 days. And you'll need to appear in 30 days. If you do not, something else will happen. You understand?
Yes, Your Honor.
Judge, can we do no contact with the same folks from the stipulations?
Who are the no contact persons? Just 1 second. Let me grab the different file. Okay, let me see if I have that file. I don't have the trial file.
Your Honor, we would agree if it makes it any easier that the same people that were named yesterday would have no contact.
All right, you understand that?
Yes,
So
Your
you'd have no contact with the previous persons that were entered into the motion
Absolutely.
for probation. You understand?
Yes, Your Honor.
All right,
Your Honor, can I speak to that then? Can I speak to the rest of the court's
Yes.
judgments? We think the amount of bond is fair, but I would think the full GPS is unnecessary. This man, if that's a concern that he's gonna run off, where does that come from?
all right. No, so here's the thing. What I stated earlier with regards to full GPS. He's retired. That's what I'm being told. If he wants time to handle affairs, or if he decides to get employment, all he needs to do, or you counsel need to do, is to come to court with timeframes for the court. But I'm not just going to give him free reign on GPS.
You know, could we have GPS with a curfew?
Once you all come back to court with a list of what time he would like to be out and about and for what reasons, the court will make a ruling at that time. But for now, it's full GPS. So that's all you have to give me. All right?
We'll be back with that. Thank you, Judge.
All right, thank you. No, that's going to be, he's appealed, so he can't go. All right, and there are no applications?
No, Your Honor.
All right, probation, no applications. Court is calling 2024 CR 007117, State of Texas versus Kenneth Galfo. Can I have parties announced for the record for the state?
Andrew Harris Sadelman.
Defense.
David Andre Woodard from Mr. Galfo.
And are you Mr. Galfo?
Yes.
Counsel, have you received all of the discovery?
I have, Judge.
Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Galfo, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented? And you're proceeding on the enhancement allegation?
We are, Judge.
All right, Mr. Galfo, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes,
And did you sign it in all the appropriate places?
yes,
Did you understand you're charged with possession of a controlled substance penalty group 1B, 1 grams to 4 grams? Normally, that's a third-degree felony with a range of punishment of anywhere from 2 to 10 years. However, the indictment is alleging a repeat offender enhancement allegation. If the state is able to prove up that allegations, your range of punishment will be at the second-degree felony level, which is anywhere from 2 to 20 years and up to a $10,000 fine. Did you understand?
yes,
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes,
Did you understand by entering this plea, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in this case?
yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Galfo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $2,000 fine. There are no applications, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes,
Defense is at the plea.
it is, Judge.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest?
To the enhancement paragraph, how do you plead? True or not true?
True.
State any evidence to support the defendant's pleas.
Contained in Exhibit 1 and attachments, Your Honor.
No objections, Judge.
All right, state you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
we are, Judge.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea, Judge.
All right, Mr. Galfo, who is Kenneth Victor? Or is that your full name?
Yeah, that's my first name.
So it's Kenneth Victor Anthony Galfo?
Correct.
Okay. And it says in here that he had warrants. They arrested him on warrants. Is there any outstanding cases?
Not to my knowledge, Judge. He does have a misdemeanor case that's going to be dismissed this morning. I don't know of any other cases outside of those two charges.
All right, State, do you know if he has any other outstanding warrants in Bear County other than this misdemeanor case that's still pending, or any open cases other than the misdemeanor case in this case?
And Judge, I checked with Mr. Garahan. He checked his system. He didn't see anything else pending.
Okay. And the reason why I ask these questions, because I don't want him to be held at the jail awaiting transfer because he has a pending case.
Sorry, Judge, Jason Garrett for the record. I talked to Mr. Woodard about it, indicated that there might have been a case from March, but in our system, it doesn't have anything else on our system at this point.
All right,
But that's not saying it's not out there somewhere.
it's
but
Odyssey.
That would, if it was a theft, which Mr. Woodard told me, we would be compensating in this. So if it doesn't rise later, Mr. Woodard or the defendant can come back and we will TIC that with that case.
All right.
And Judge, what I can do is I can follow up with it to make sure nothing else is lingering out there.
All right, because there is overcrowding at the Bear County Jail. And
He
we
told
would
me
like
about
you to
that.
have you transferred to the prison, okay? And your attorney will let me know.
Okay.
All right, State, you're excused.
Your Honor, may I tender the dismissal?
Yes.
Fully County Court 1 will not mind you signing.
Thank you.
Thank you, Your Honor.
All right, so the court, as previously stated, is finding you guilty, the enhancement true. The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. And there's to be restitution, if any, to SAPD for drug testing. Counsel, anything else with regards to sentencing?
No, Your Honor, thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. How old are you?
46.
All right, so you're gonna have to start making changes in your life. If you come back to another felony court in Texas, and I'm only dealing with Texas law, I don't know what they're doing in other states. I'm sure research would let us know. You'll be a habitual. And depending on the type of felony, your minimum will be 25 years in the prison. So if you have a drug or alcohol problem, you need to take care of it. When you're released from prison, if you can't find a place that will accept you in inpatient treatment if you need it, if I'm still on this bench, as they say, God willing, the creek don't rise, you can come back here and I will direct you to where you need to go for help. You understand?
Yes.
Don't wake up and find out a majority of your life has been spent in prison. You understand? All right, good luck to you.
Final outcome: Gallo is convicted. The enhancement is found true, and he receives 2 years in prison, plus a fine and restitution, tied to drug testing. The judge's warning was blunt. Another felony could mean decades behind bars. Like, share, comment, subscribe.
Hello, Mr. Gomez.
I just seen you on YouTube, man. In the dorm, I saw YouTube. You're
Yes.
awesome.
Well, thank you so much. I appreciate that. I try my best. That's all any of us can do, right? All right, so where are we on this case?
I conferred with my client, conferred with the state judge. We have an offer. We're not able to reach an agreement at this point.
All right, was the offer tendered today?
No, it was tendered before and I tendered it to my client.
All right, so you're requesting a jury trial?
Yeah.
All right, we're gonna bring you back tomorrow for jury trial.
Okay.
And I need an acknowledgement of discovery sign.
I think there's already one, but I'll double check.
If there is one already signed, Your Honor, would you like another?
No, it's just that it's not in my file, but if it's uploaded in the system, sometimes things make it to the system and they're not in the file. So do you have any questions?
Like everything that happened to me, like they went inside my house, right?
Yeah.
Oh, okay.
All right, let me explain something.
Oh, no,
to
you're
you.
good, ma'am. No, you know, I
No,
know it's a
let me-
my letter.
Let me explain something to you. Sometimes people get arrested for an offense and maybe they feel they're not treated appropriately.
Yeah.
The fact that you may not have been treated appropriately after your arrest, that really doesn't have anything to do with the allegations. Unless the defense says, oh, this has something to do with the allegations. I will tell you, I've been a defense attorney, and sometimes I would have clients, they would be focusing on what happened at the arrest. And I would tell them that's a separate case. Maybe that's a civil case. Maybe that's charges for something else. But right now we have to focus on the charge.
Yeah.
So in your case, this is the charge.
Yeah, but the owner of the house.
Let's not talk about that.
Oh, okay,
Save
okay,
that
okay.
for the trial.
Okay.
All right, so we're gonna bring you back tomorrow for trial. You'll be brought over dressed in whatever clothing. I'm
Yes.
assuming it's this clothing,
Yeah.
unless there's a clothing exchange that's completed. And counsel, if there's an issue with the clothing exchange, let the court know. All right, we'll bring you back tomorrow.
Ma'am, have a nice day.
All right, thank you, you too. All right, court is calling night mag number 754053, 754054, State of Texas versus Jesus Rivera. Could our parties announce for the record for the state? Defense?
Elizabeth Settle.
And are you Mr. Rivera?
Yes, ma'am, I am.
All right, defense in each of these cause numbers. Off the record. Mr. Featherston, we're on the record. Y'all need to move it towards the end. Thank you. All right, we're back on the record. And each of these cause numbers, your attorney has filed a motion to reinstate bond. With regards to the reinstatement of the bond, was he on a PR bond or no?
No, he was on a commercial.
All right, so one, before I can even consider reinstating his bond, the question becomes whether or not the bondsman wants the bond reinstated. Because I have no authority to force the bondsman to be back on your bond.
Correct. And he has been paying regularly, Judge, if you want me to step out and talk to them about it.
Yes, if you'll call the bondsman and see if the bondsman wants to have the bond reinstated. And then I can make an informed decision on whether or not I will reinstate his bond.
Sorry for the another
No,
delay.
it happened.
Okay.
That's okay.
Okay, we're gonna take it on this side so the picture down. We should find them.
We're gonna go on the record and night mag number 754053 and 754054. Could I have parties announced for the record for the state? Defense?
Elizabeth Settle.
All right, and are you Mr. Rivera?
Yes, ma'am, I am.
And each of your cause numbers, your attorney has filed a motion to reinstate bond and to have installed the PAM device in lieu of ignition interlock. State, have you had a chance to review defense's motion to reinstate bond?
Yes, Your Honor.
All right, State, do you have any objections to the reinstatement of the bond?
Yes, Your
All right, then defense, do you have any witnesses?
Just my client, Judge.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, all the truth.
All right, you can lower your hand. Make sure
Yes, ma'am.
that you wait until the question is finished before you answer. Do you understand? All right, state your name for the record.
My name is Jesus Rivera.
All right, defense, you may proceed.
Thank you, Judge. Mr. Rivera, you were on bond for both of these cases that we're here for, correct?
Yes, ma'am.
And your bondsman is AA Best.
Yes, ma'am.
Now, you understand that the judge put conditions, pretrial conditions on your bond as a condition of you being on bond that you needed to follow.
Yes, ma'am.
Are you aware that one of those conditions was to have the ignition interlock on your vehicle?
Yes, ma'am, I didn't know that.
All right, so here's the thing.
Yes, ma'am.
I'm assuming that you want me to hear what you're saying.
Yes, ma'am.
In order for me to hear what you're saying, you're going to need to speak up
Yes,
because
ma'am.
right now I'm catching every other word that you're saying.
Yes, ma'am.
All right, you may continue.
You were aware of that condition? correct?
Yes, ma'am.
And yet you did not have the ignition interlock installed?
No, ma'am.
And why is that?
I don't have no vehicle.
Okay,
I take the bus to work.
did you discuss the fact that you have no vehicle with your
Yes, I talked
pretrial
to,
officer?
I talked to Fabian Ortiz.
Okay, and what was the response?
I told him and he just told me that I have to get a vehicle to try to install it.
Did he give you any other options?
No, ma'am, he didn't.
Have you driven at all since you've been on bond? for
No,
this?
ma'am.
case. Do you have any minor children?
I got 4 children. Oldest 12 years old, 8, a boy, and a 4-year-old and a 5-year-old.
Do any of them live with you?
No, except for the one, 8-year-old.
The 8-year-old lives with you.
Yes.
Are you a single father?
Yes, ma'am.
Do you work to provide support for
ma'am.
your family?
Yes, ma'am, I do.
And are you asking the judge to reinstate your bond with the revised conditions so that you can continue to work to support your family?
Yes, ma'am.
Thank you. I'll pass the witness.
All right. State, any questions?
Mr. Rivera. When was Ms. Settle appointed to represent you?
I think it was March the 13th, if I'm not mistaken.
And you were provided with her contact information, is that correct?
Yes, sir.
And so you were aware that if you had difficulties with your bond, you could contact Ms. Settle and ask her to go to the court to have that issue resolved, correct?
Yes, sir.
Did you do that?
No, sir.
Nothing further.
All right, any other questions?
No, you're not.
All right. Is there any objections to Fabian Ortiz zooming in?
I have no objection, Your Honor.
And your testimony is that Fabian Ortiz told you you needed to get a vehicle so ignition interlock could be installed on it?
Yes, ma'am.
All right, we're gonna have Mr. Ortiz zoom in. Ms. Ferguson?
Yes, ma'am.
If you could have Fabian Ortiz, he's the pretrial services officer on this case. If you could have him zoom in, please. All right, just have a seat. We're gonna get him to zoom in. All right, court is calling 2023 CR 0562A, State of Texas versus Thilda Thanasuk. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Robert Featherston, representing Ms. Reyes.
All right. And what is the name on your birth certificate?
Tita Tanasu.
All right, so your name is Thilda Thanasuk.
No, there's no L.
No L?
No L.
So it's
Tita Tanasu.
THIDA?
Right.
Thanasuk. So you're being referred to as Miss Reyes. If you want to legally be Miss Reyes, then you need to get that changed in a court of law. Otherwise, your name is Thanasuk. Do you understand?
Tanasu.
All right. And are we proceeding with the motion to revoke?
Your Honor, no. Ms. Reyes has indicated to me that she wants to withdraw her application for a court-appointed attorney and to hire her own attorney. I'm assuming that she's going to waive the 20-day statutory requirement for the hearing. Her reasoning for that is if the court wishes to inquire.
No. Oh, so here's the thing. We're going to come back in 10 days. This is going to be set for a contested hearing. Mr. Featherston will be here to handle your case for a contested hearing, or either you will have an attorney. If you're hiring an attorney, you need to let that attorney know that this is going to be a contested hearing in 10 days. Do you understand? All right, Ms. Ferguson, recall this in 10 days, please. All right, we're going to come back on August 20th for a contested hearing.
Thank you, Your Honor.
You're welcome. All right, we're back on the record in night mag number 754054, 754053, State of Texas versus Jesus Rivera. We have the pretrial services officer Fabian Ortiz by Zoom. Any objections to this witness appearing by Zoom? State?
None, Your Honor.
Defense?
No, Your Honor.
Mr. Ortiz, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
It's Officer Fabian Ortiz, Bear County Pretrial.
All right, defense, do you have questions?
Yes, Officer Ortiz. You were the pretrial officer, are the pretrial officer for Mr. Rivera, is that correct?
Yes.
And one of the conditions of his bond was ignition interlock.
That's correct.
Did he inform you that he does not have a vehicle?
From what I'm aware of, I believe so, yes.
Okay. And do you remember what your response was when he told you that?
No.
I'll pass the witness, Your Honor.
State any questions.
Officer Ortiz, are you refreshing your recollection from notes taken contemporaneously with speaking with Mr. Rivera?
Just off of my head, not my notes.
All right, thank you.
All right, Mr. Ortiz.
Yes, Judge.
Mr. Rivera informed you that he did not have any vehicle. Did you tell him or give him any information on the steps to take to have something other than ignition interlock?
I'm gonna go ahead and check my notes on that, Judge, right now.
All right, thank you.
When conducting the orientation on March 6th, the defendant did inform me that the vehicle was a total loss and that it was his mother's vehicle.
All right, and so did you give him any other options for him to be monitored for alcohol use?
Let's see. No.
All right, so if he were released on bond, how long would it take for him to have the PAM device installed in lieu of ignition interlock?
Not that long, Judge. I can go ahead and provide him with the email with the approved vendors, and he can make an appointment to get installed with the portable breathalyzer.
All right, so if the court requires him to have this installed by Friday, is that enough time for him? Or is that not reasonable?
Each vendor's different, Judge, so it would just depend on when the availability of the vendor is. I can try to make contact with the vendor that he decides and see if we can make an exception if there's availability.
All right, thank you so much. If you'll remain on Zoom, this is what the court is going to do in each cause number. Because it appears there may have been some miscommunication. So, and defense, you've informed the court that the bondsman is willing to be placed back on bond.
Correct, Judge.
So in each cause number, the court will reinstate the bond. The court is going to order the PAM device in lieu of an ignition interlock. The PAM device is to be installed no later than August 12th by 3 p.m. You're going to provide an affidavit of non-driving. You're not allowed to drive at all. Do you understand? So there's to be an affidavit of non-driving. And there's to be an affidavit showing that the vehicle that was used was inoperable. All right. Mr. Ortiz, is there anything else that's needed for him as a condition of bond you feel he would benefit from?
No, Judge, I just want to remind you that there was the conditions of just no alcohol use and no possession of firearms, just in case that wasn't addressed right now. If that's still a current condition.
All right, all other previous conditions will remain. Of course, with the exception of ignition interlock.
Thank you, Judge.
All right, and then Mr. Rivera, I'm not the one who placed you on bond for this, so there are a few questions I have for you. How often are you drinking alcohol
I don't drink.
in the past?
It was like Friday, that was it.
All right, I'm gonna ask him to do sober support meetings. And we're gonna do 60 and 60 days. All right, is there anything else from either side?
Nothing to stay here on.
Nothing from the defense, Your Honor.
All right, so we're off the record and you may be excused.
Just to recall the warrant.
No, I put it in here.
Gotcha. Okay, thank
All
you.
right, so what I'm gonna want you to do, if you'll speak to Miss Ferguson, she will give you the link to this Zoom meeting. I'm gonna put Mr. Ortiz in a breakout room, and then once you zoom in, you and your client will be in the breakout room so you can coordinate the conditions that I put in place.
Yes,
Right.
Judge.
So, Mr. Ortiz, if you could remain, please. I'm gonna send you to a breakout room, and as soon as defense counsel zooms in, I will send her to the breakout room with her client as well.
Thank you, Judge.
All right, and Mr. Ortiz, any questions about what I'm requiring?
No, Judge, it's clear. Thank you.
Do you have any questions about what I'm requiring?
No, ma'am.
All right. So you're all excused, just get with Ms. Ferguson so that we can create, so that you can, I'm sorry, confer with the pretrial services officer in a breakout room.
Yes, I've got it, Judge.
Okay,
Thank you.
you're welcome.
Have a good day, Smith.
Thank you.
Was the warrant reflected?
Yes, the warrant was recalled. All right, he comes there and he has a Care Bear as a Ghostbuster.
Yes.
All right, so you're dressed inappropriately for court. Do you realize that?
Yes.
All right, so why are you dressed inappropriately? Did you not know courtroom attire?
Be honest with you, no, I did not.
I'm sorry, what?
To be honest with you, I did not.
All right, so here's the thing. And your counsel will tell you, I used to be a defense attorney. I used to tell my clients, dress like you're going to church. But then I realized you can't say that these days. So for court, I don't require people to be wearing a Gucci suit or Armani suit or whatever. If you come to court wearing a pair of jeans, not the ripped ones, just regular pair of jeans and a shirt, that's enough for the court. Because I realize everybody doesn't have a suit that they can just pull out of their closet and let me put on a suit and tie. You understand?
Yes, ma'am.
So next time you come to court, you need to either be in long jeans or some khakis or whatever, but I require long pants and you need an appropriate shirt. Although I do like that. Which Care Bear is it? Do you know?
It's a collaboration shirt between
Okay.
Ghostbusters and Care Bear.
All right, we need to know which Care Bear that is.
No, but apparently it's a dead Care Bear.
Right? Yeah, it does look sort of hazy. All right, who's the state on this case?
Jason. Carry hand.
All right, court is calling CM 119737 and 119735, State of Texas versus Isaac Cabello. Could I have parties announced for the record for the state?
Jason Garrett, you're on.
Defense?
Robert Mauer for defendant.
All right, and are you Mr. Cabello?
Yes, ma'am.
Right, defense has filed a motion asking that your conditions of bond be modified. State, have you had a chance to review those documents? All right, defense, what are you requesting?
Judge, we're requesting modification to tracking only. I've spoken with the intake DA. Apparently the case is still with the paralegals. After 3 months, I'm not quite sure what the delay is. But we requested it's a really weird, unusual stalking case. It's not family violence. But Mr. Willis is going to look into see if he can try to find the surveillance video. My client manages apartment complexes all over South Texas and also in California and New Jersey. So we're just asking for tracking only. He's been on partial. And then once I get the evidence from Mr. Willis, I'll come back and either talk to him or talk to Jason about removal if we feel it's appropriate.
All right, so here's my question. Does the complainant know about this request?
Judge, the complaint, if I can give you the background on this, this is a neighbor. They had a dispute over a trash can. And my client was at the police headquarters filing eviction notices with SAPD when these people came in
saw him there and they alleged he was stalking. That's why we requested the surveillance video from SCPD headquarters for Mr. Willis.
All right, this is what the court will do. The court, and state you're in agreement with tracking.
Yes, Your Honor. I've talked to Mr. Mallon.
All right, so this is what the court is going to do. The court is going to order tracking only, but tracking only will not begin until August 8th. And if you all can let the complainant know.
Okay.
All right. Is there anything else?
No, Judge.
All right, then you are excused.
Thank you, Judge.
All right, so defense is here asking that he be placed on partial house arrest so that he can work.
And waive fees, Your Honor, yes.
Oh, well, the fees, they'll be, yeah, I'll order that they be waived. So the only issue that needs to be addressed. State, are you going to be objecting to the partial house of work for employment?
No, Your Honor.
All right, we're going to go on the record in 2022 CR 1746 and 2022 CR 10355, State of Texas versus John Michael Garza. Could I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Defense?
Victoria Cruz on behalf of Raymond Martinez for the defense.
And are you Mr. Garza?
Yes, ma'am.
All right, defense has filed a bond modification requesting that GPS fees be waived. I'll order that they be waived, but it's a third-party contract. I don't have any jurisdiction to force them to waive your fees. Do you understand?
Yes, ma'am.
Now, with regards to partial house arrest, it's the court's understanding that the state does not have objections. Does your client currently have employment?
He is a skilled electrician by trade, but I do not believe that he has a set employer right now. Is that correct?
No, no, but you can. My uncle.
You going? Okay, so he will be employed. You understand that we're gonna have to provide GPS, the schedule and the locations and all of that?
Yes, ma'am.
Okay.
All right, the court will grant the motion in each case. The court will waive GPS fees. And you're to provide your employer and your work schedule. Do you understand? All right, is there anything else?
No, Your Honor.
All right, then you're excused.
Thank you very much.
You're welcome.
May I be excused, Your Honor?
Yes.
Thank you.
All right, court is calling 2019 CR 8173, State of Texas versus Amanda Lawson. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Ray Lopez, Your Honor.
And are you Amanda Lawson?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Amanda Nicole Lawson who was placed on deferred adjudication in 2019 CR 8173 for the offense of unauthorized use of a vehicle on November 14th, 2019 for a period of 4 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state?
Yes, Your Honor. Violated condition number 5 in Burke County, Texas. The defendant Amanda Nicole Lawson, who did in there failed to report the supervision officer as directed for the month of October 2022.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated condition.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Stand that, but I'm in hopes that you'll hear me out.
No, my question is, did you understand that? Knowing that, do you still wish to plead true to violation of condition number 5? I'm sorry?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there proposed agreement?
No, there's not, Your Honor.
State, what are you requesting?
Revocation, Your Honor.
Defense?
We're going to request that it should be placed back on probation, and my client would like to testify to give a reasons report.
All right, if you can raise your right hand, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Amanda Lawson.
All right, and what would you like to say?
Miss Boyd, because you gave me a second chance 2 years ago, I went to Grace House and I changed my life. I've been sober for 2 years. I was released from Grace House because I had a surgery and I had to go home and take care of my family. I've been doing nothing but going to work and going home. I was scared. I understand that being on the run for 2 years is bad, but I was scared that I was about to lose everything that I just worked really hard for. because of you, I changed my life, and I'm just hoping that you believe in me one more time.
All right, this is your second motion to revoke. And what I do know is that each time when persons appear before me, I ask them if there's anything that the court can do. Do they need anything so that they can be successful? And I know that I tell people, if there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to court. So you've been here before. You were placed on probation in 2019. And then you came back in 2021 and you pled true to a violation of condition number 1, which is a new offense. And then the court altered and amended your conditions and continued you. And then now we're here and nobody has seen you since 2022.
I'm scared. I was at home. I was taking care of my family.
Why
I
don't you pick up the
resided-
phone and call probation?
I was scared. I can't have no excuse for that, Miss Boyd.
Okay.
I was scared to lose everything I've just worked so hard for. My grandma is 75 and my grandpa is 95, and I have my kids back in my life. I have a relationship with them now. I've been sober since Grace House. I haven't worked so hard for something. It would just destroy me to lose it again and start over.
All right, so these are choices you made.
Yes, I understand that.
You made the choice not to report.
I understand that. I'm just hoping you'll believe in me one last time.
All right. Any questions?
She said all.
Any questions?
No, Your Honor.
All right, the court is going to grant the motion. The court is finding you guilty. Does anyone want to speak with regards to punishment? State?
Yes, Your Honor, the state's requesting 16 months, state jail.
Yeah, we're requesting the minimum. It has 166 days in. We also have some credit for the time she served and.
All right. So what I can tell you, Ms. Lawson, the state is requesting 16 months. I had internalized everything you said. And actually, what the court was going to do was sentence you to 2 years in the state jail facility. But the state is requesting 16 months. So I'm going to sentence you to 16 months in the state jail facility. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, you were given chances. And in this court, I don't know how other courts do it, but in this court, it is better to ask for permission than forgiveness. All you had to do was pick up the phone and call your probation officer and say, this is what's going on in my life. And if they did not address it, you know what you could have done? You could have come back to this court, come back to me, and I would have figured out what was going on. But for you to behave as though you were not on probation, that's a problem. You understand?
Yes, ma'am.
All right, good luck to you.
Final outcome: Lawson's probation is revoked. She's found guilty and sentenced to 16 months in state jail. Despite her claims of sobriety and rebuilding her life, the missed reporting ultimately cost her freedom. Like, share, comment, subscribe.